I declare the House in committee for consideration of the Hurunui Kaikōura Earthquakes Recovery Bill. Mr. Chairman.
Mr. Speaker. Someone going to move that?
I think is Mr. Brown.
I'll sit leave, shall I?
Mr. Chair.
The Honourable Jerry Brownlee.
Mr. Speaker, Mr. Chair, I move that the committee consider the whole of this bill as one question. Given the process that's been used to develop, I'm seeking leave. Yes, definitely, I'm seeking leave, Mr. Chair. Yes, I know. Yeah.
Leave is sought for that purpose. Is there any objection? There appears to be none. Members, the House is in committee on the Hurunui Kaikōura Earthquakes Recovery Bill. The question is that parts 1 and 2, schedules 1 and 2, and clauses 1 and 2 stand apart. The Honourable David Parker.
I think the members of the Select Committee who have sat on this over the last week are just about asleep on their feet, so we're wanting someone else to take the first call and cover the general and then just pick up the little rats and mice that were left. So if I could I begin by thanking Minister Brownlee. Minister Brownlee came to the committee yesterday to try and resolve the issues that were left outstanding after our deliberations, and was very reasonable in his dealings with the committee. And I think that's why we've got to the point where there's near unanimity around the terms of this bill. Could I say a few things about it, sir? Firstly, the content of the bill is informed by the experience in Canterbury and the report of the Regulations Review Committee pursuant to the inquiry that Parliament requested the committee to do as to how far regulation-making powers ought to go once if you have emergency legislation following an earthquake. The central proposition of the Regulations Review Committee, which reflected an earlier finding years back from the Law Commission, is that it's actually impossible to have legislation passed in advance covering all of the potential eventualities arising from a large disaster like an earthquake, unless the empowering legislation is so broad that it would potentially confer, in the event of a disaster, powers to the executive that are broader than necessary. And for that reason, when we have an earthquake, it's necessary to have bespoke legislation to address the powers that are needed. And as I said in the first reading of this debate, my view on these sorts of powers is the same as it is in respect of taxation: as little as possible but as much as necessary. And so the philosophy that I took and the Labor Party took to this Select Committee is that we needed to give the executive as fewer possible powers to override primary legislation as is possible, but as many as were necessary. Sir, with that in mind, I think we've largely achieved that. There are two aspects that I don't find perfect. We're not voting against the bill on that basis, but that I will refer to. But in the main, I think the Select Committee, with the help from officials and submitters, has got to a reasonable place. Sir, there are some changes that have been made by the Select Committee which are detailed in the supplementary order paper, which has now been tabled by the Honourable Jerry Brownlee. Because of the pressure of time, there's no time for PCO to prepare a revision track version of the bill, and therefore the changes proposed are set out in the supplementary order paper. A lot of them are pretty technical. Dennis O'Rourke made some useful suggestions to changing the purpose clause that's been caught up, that it's been incorporated in the bill. Officials with scrutiny from the Select Committee found that there were a number of acts listed in Schedule 2 that weren't in fact needed to be in there. They didn't need to be in there. I should at this point say, sir, that in respect of that list, the way in which this Act deals with it compared with the Canterbury Act, instead of having a list of a few acts that can't be overridden, like the Bill of Rights Act, and then saying anything else can be, this bill is more restrictive in that it sets out a list of the acts in Schedule 2 which can be overridden, but still has a list of a few acts like the Bill of Rights Act that never can be. Sir, the two areas that I was not completely convinced by at Select Committee were both raised by, also raised by some of the submitters like Professor Andrew Geddes and also in one case the New Zealand Law Society. The first of those two, sir, is I don't think there's a need to oust the jurisdiction of the court. It is true that there is a residual ability of the courts to hold illegal a order in council overriding statutes that is plainly outside the terms of this Act. So that would happen, for example, if the Minister attempted to override an Act that isn't on the Schedule 2 list. But I personally think we shouldn't be even limiting, shouldn't be at all limiting judicial review rights. The bill does limit judicial review rights around process decisions and other decisions that the Minister takes under the Act. I don't think that was necessary. There's already a very wide discretion for the Minister. The test of his decision-making is a subjective one, it's not an objective one, which gives him great latitude. I don't think we should be scared of the courts having a judicial review function that isn't prescribed in any way. Mr. Chairman, for example, some of the concerns that you'd get an activist court, I think, are misplaced. If there was an application, Mr. Chairman,
The Honourable David Parker.
if there was an application to challenge the validity of a Minister's decision under this legislation, that application doesn't stop any process. It's only if the court grants a remedy that would stop a process. Even then, it's unlikely that the remedy would be an injunctive one if the government was saying, look, this is necessary in the face of an emergency or a situation post-earthquake. In any event, the Select Committee has gone so far as to clarify that there is a residual judicial review right. It's just not as broad as I would have liked it. So the other issue before I sit down is the geographic breadth of the legislation. It includes already the Wellington region. The geographic impact of this bill is potentially from the Waitaki River to the north of the Wairarapa, when the serious parts of this earthquake sequence have been around Kaikōura. Seems to me an unnecessarily geographically broad area. It's one of the submitters, a number of the submitters made that point. I would have preferred that we narrowed it. If you're going to have such a long list in Schedule 2 as we've got, it's hard to see why those powers should be conferred in respect to the Wellington area. I know that there are people concerned that we could yet have another large earthquake in the Wellington region, and they would like to have the capability to invoke those powers should that terrible thing happen. I think you wait until that sort of thing happens before you confer those powers rather than conferring them in advance. However, sir, as I've had previously said, I accept that the Minister, who has had broad powers under the Canterbury legislation, has not misused them. And with those comments, sir, I note that the Labour Party will be supporting the bill.